Now, there are two important cases that I just want to highlight before I move on to the last duty around what this duty of investigation actually means on a day-to-day basis. So there was a case in Diaz. In the case in Diaz, and the adjudicator said the following. And he said that, and I quote, "As I have heard previously, there is a duty on the board to conduct an investigation and take all reasonable steps necessary to locate the dependents of the deceased. Now, there is a common misconception amongst parties in the pension funds industry at large that there is a duty on a dependent to come forward and inform the board of his or her status as a dependent. This is not so. The duty is placed squarely on the board to trace all the dependents of the deceased." End quote. This statement of law, while it was made in the context of South Africa, applies squarely in Botswana. The duty is on you as a board to go out there and find the dependents. Whether they come forward or not, you have a duty to investigate them. Even when they come forward, that duty doesn't end there. It doesn't relieve you as a board of your duty to investigate. You must still investigate the information that has been given to you. Right? So you cannot wait for dependents to come forward. You must seek them out. You have to find out that there is a maintenance order issued by a court in Lobatse and that there's a dependent there. It's your responsibility. The second case, and then I'll move on. There's a case in Pete versus Sakau Beneficiary Fund. Now in here, the adjudicator made some statements that frowned upon the practice by pension funds to obtain affidavits and make decisions solely on the basis of them. Now I'm trying to say to you today that that's not the right way to to comply with your duty to investigate. And this is what the adjudicator said, and I quote, that this tribunal views the board's action in a very serious light, as it is evidently abdicated its responsibility of conducting a thorough investigation in order to identify beneficiaries. Evidently, the board made no effort to conduct an investigation, but relied on the affidavits submitted by the complainant without verifying whether or not such information was correct. In the circumstances, this tribunal is of the view that the board failed to conduct a proper investigation. Right? So, you need to do more. That's the message here. There have been many cases, and I can go on and on, about emphasizing this duty to investigate. Now, does this mean that we shouldn't rely on affidavits? No. We should, because oftentimes it's a starting point. I think that human beings are good by nature. But when they know that they stand to benefit, they can tend to wear aside. So, but we must rely on those investigations. The third duty that I spoke about is a duty to make an equitable distribution. Now, you might ask the question, well, how do we ensure that we make a fair decision? Because fairness is a very concept that, it's different from person to person. So how do we ensure that we make a fair decision? Well, Regulation 29, subsection 5, provides some guidelines to the board on what would be considered fair. And it says that the board may consider the following factors in making a fair distribution. Now, this duty comes after the board has now identified who the dependents are. So you now know who the dependents are. You now know who the nominees are. It's now time for you to determine who must get what and how much, right? We have also decided that the nomination is not going to be followed. We are going to make our own decision because we think that's what is fair. So these are the factors that the Act now says you must consider. First, It says you must consider the degree of dependency. To what extent was the dependent dependent on the deceased? Was the deceased dependent 100%? Was it a partial dependency? What was the level of dependence? Now you begin to see here, investigation is important because you have to seek out that information. Right? The second is you must also consider the age of the dependent. What are the ages of these dependents or beneficiaries? Because the younger a beneficiary is or a dependent is, the more they are going to need in financial support, isn't it? The nomination form. Remember that we get to this stage because we are not paying according to the nomination. But that doesn't mean that the nomination gets to be thrown out of the window. We still have to consider what the member said in their nomination. Right? So there should always be a nomination. Do we agree? Because there's a duty for you to ensure that there should always be a nomination. So there should always be a nomination before you as a board. If there's no nomination, that means you didn't comply with your first duty, isn't it? So you're already in some risky situation. Then the last one is that any distribution that was made by the deceased in his or her will must also be considered. So here, I gave an example earlier of the life insurance policies, right? If the member had a will, and in that will, the children and various other people have been given some benefits, that you have to consider that as well in deciding what is fair. Right? Remember one thing here. All the people that you are considering, they are all dependents. So you cannot discriminate between dependents. The only basis in which you can discriminate lawfully is by considering these factors. So on the basis on which you will say, well, we know this one is a dependent, but we think this dependent, it would be fair for them to only get 10% as opposed to this dependent who is a child, age 2, we think that they should get 50%. Okay, so this is the only instance where you've been given the power to be able to lawfully discriminate on the basis of the grounds that have been given to you in the Act. Now, the last point for me to make here is that there's no hierarchy in these factors. So not one factor counts more than the other. One doesn't override another. All of them are relevant. You have to consider all of them and then make a decision. The duty to pay. At the end of the day, our duty is to pay benefits. That's what pension funds are there for. Pension funds are there to pay benefits when members retire or when members pass on, for those benefits to be paid to the dependents. That's the duty. That's why pension funds exist. All right? So, the duty to pay. The Act mentions that where there are no dependents, the board must ensure that within 12 months, if no dependents exist, no nominees exist, then the money must be paid to the deceased estate. Right? This is the only time and time frame has been mentioned. In relation to all other payments, time frames are important, but what is very important is to ensure that the rightful people get the benefits. So in other words, if it takes time for you to conduct an investigation, and as a board, you don't feel that you have enough information to make a decision, you are not obliged to make a decision. You must make a decision when you know that you have all the right information before you. Right? But you must also keep in mind that you don't want those people, the dependents, to wait forever. Because life must continue for them. Right? So, the Act talks about the following methods of payment. It says that as a board, you can pay to a trust, and that will be deemed to be a payment. You can pay to a person recognized in law or appointed by a court as a person responsible for managing the affairs of a dependent or a nominee. You can also pay to a beneficiary fund. Right? Now, I know beneficiary funds may be new in Botswana, but I think that it is probably high time that trustees in Botswana begin to think about different ways of paying out benefits in ways that are more efficient. And I think beneficiary funds, from my experience, are one of the best ways to ensure that monies are going to reach out to people in ways that are risk-free. What is the risks associated are managed. Beneficiary funds are regulated by the acts. There are some tax benefits for it. Monies can be ring-fenced, and also they can be invested. So I know you were talking about investment earlier today. Monies that are paid into beneficiary funds for dependents can also be invested. It can also grow so that it can actually go longer to support those dependents. Then in closing, in reaching out towards the end here, is that I was asked to make a few remarks about the impact of the RFA on the Matrimonial Causes Act. Now, the part that I want to just mention, this can be a topic for another day. We can talk more about it. But the only aspect I wanted to talk about is the following. So Section 40 of the RFA gives the board the power to deduct certain amounts from pension benefits, including death benefits. And the most apparent impact on the RFA is that a board may be expected to deduct amounts that have been assigned to a non-member spouse in terms of a divorce decree that is issued under the Matrimonial Causes Act. Now, I emphasize the word may deduct because whenever Parliament uses the word may, it means that it's not a must. You don't have to do it. It is a discretion. But it is a discretion that must be exercised according to certain factors. So certain considerations must come into play. Now, in this context, the Act says that a deduction may be made, but a deduction cannot be made if the deduction would not deplete the benefits that are available. And secondly, it also provides that if there is a maintenance order against that deceased, any deductions that may be made in terms of a divorce decree will take second preference. A maintenance order will override a divorce decree. And the reason is very obvious, that Parliament wants to promote protection, that we want to maintain that financial dependence. Maintenance orders are issued because of financial dependence that the court has found that exists, and that they want to maintain that. And that, consistent with the Section 39, is what the board is also asked to ensure that it upholds. Now, the power to deduct presupposes the power to withhold benefits. There is no express power for boards to withhold benefits. But if you read Section 40, one of the instances in which benefits can be withheld is if a member in their working life had either embezzled money from the employer or stolen money from the employer and admitted in writing that they stole that money, or the employer obtained a judgment against them to recover that money, the board may deduct from such monies. But there is a case in South Africa decided by the Supreme Court where it ruled that the power to deduct also implies the power to withhold. Because if an employer takes a member to court, and during that court process, as you and I know that court processes take time, during that period, while you're waiting for a judgment to come out, the member exits the fund, resigns. At that point, if they resign, they're going to get their money, which means that the employer will not be able to recoup that money that the member would have embezzled. So should we let the employer, in the dry in the court because they don't have a judgment. They are waiting for a decision from the court. So what the court ruled is that in that instance, the board has a discretion to withhold that benefits, to wait for that court judgment to be issued, and then to decide at such stage whether to deduct or not. So that is a limited instance in which the power to withhold comes about. Now, I don't know how the courts in Botswana are going to interpret Section 40. They might interpret it in the same way as their counterparts in South Africa. We don't know. So I'm reluctant to make sweeping statements to say that there is a power to withhold in the Act. It is subject to what the courts in the land are going to say about it. But if there is a power to withhold, that power only means that the employer must take steps to recover that money. So you can't withhold and then the employer just sits and doesn't even go to court. A court process must be in process. So we must be withholding because we are waiting for a court judgment. But you also can't withhold monies indefinitely because we don't want to prejudice the member. In Botswana, as far as I remember, the constitution presumes everyone innocent until proven guilty. So you cannot withhold. So we are limiting a person's rights in a very limited instance. We don't want to do it for a long time, for good reasons, as what the court have said. So all I'm saying is that I think this is a new law. The courts have not yet interpreted it. We are going to see how the courts are going to interpret some of these provisions. But at least there's something that you can rely on to make an argument, depending on who you are. Whether you are the employer or whether you are a member, there's something that you can use to make an argument one way or another. And that's the statement I want to make. So in conclusion, I think it's fair to say, very clear, that the Retirement Funds Act gives clear duties on death benefits to trustees than in the past. In the past, the Act, the Provident and Funds Act, was very dicey about what the duties are. And it created, I think, a lot of difficulties for trustees to implement. This one is a bit more clear, right? So, but that doesn't mean that it's always as clear. I think there will still be some areas where there will be some difficulties to implement. I think what trustees should do, and I would advise trustees in here that, get a copy of the Act. Read it for yourselves. In some instances, it's very clear. Start with the definition section. You need to understand what the words that have been used in there mean. Start from there and then move on to it so that you can also begin to empower yourselves as to what your responsibilities are. When you are in doubt as a trustee, the Act gives trustees the power and the discretion to seek professional advice under the expense of the fund. So you have no excuse to say, I made this decision, I didn't know the law. You have no excuse as a trustee. If you don't know, go and seek professional advice. That's the message that I would like to leave you with.